in the last week, we have been enlightened about the existence of 5 pieces of indisputably discoverable, and at least in one example, exculpatory evidence, which ought to have been disclosed by the prosecution over the course of the last couple of years and wasn't. And we have a motion to dismiss pending in front of the court, amongst other things, for egregious governmental misconduct, including just a complete indifference and ignoring of their Brady and discovery obligations. So certainly the more we learn about evidence that should have been disclosed and wasn't, we're going to inform the court. And frankly, it's scary. Some of this evidence we discovered on Twitter through prosecution witnesses who clearly were in the custody and control of the prosecution for years, didn't disclose the evidence. They didn't make any effort to investigate. The remainder of the evidence that's cited in the affidavit comes from a Freedom of Information Act request made by a third party who is embroiled in litigation with the DA's office because of their non-disclosure, and other government entities, their non-disclosure of evidence. And the question becomes, why the hell are we getting state police and DA communications involving witnesses from the Norfolk DA's office, releasing them to the public, but a specially assigned prosecutor to our case telling us we have everything is not turning over this evidence? And this has been going on for months, years, and whatnot. And, enough is enough. And, I don't think I've ever in 20 something years, 27, I think now, in dealing with criminal practice, submitted one supplemental affidavit in support of a motion, let alone 4 or 5. And I can't even tell you that this will be the last one, because if you're asking me, do I think we'll learn more before December 5th? I'd say probably we will, right? Why wouldn't we believe that? So, we just want the new judge, as it were, as we have a new judge assigned for this, to be fully aware of everything and understand the larger point, the macro point. The micro point was there's all these emails we didn't get, an exculpatory recording, but the macro point is you can't trust these people when they say we've disclosed all the evidence, because the clear record establishes the exact contrary to that representation. And at what point is enough enough? And, we believe, and will be heard on December 5th, that we've long crossed that threshold, that this case needs to be dumped.
Mark, this is something we talked about when we were on the courthouse steps last time. At that point, we were waiting for the order just been given. 30 days, there needs to be a new prosecutor appointed. That was in the case, now dismissed.
Right.
But it was the same question. What's the consequence of just blowing off these court orders and deadlines? And there doesn't seem to be any consequence.
There doesn't seem to be any consequence. It appears to be just the way things are done there. But what is interesting is this, and again, we don't have all the facts, but my dealings and our dealings as a defense team with the prosecutor have been entirely professional, even though we clearly disagree about the case. But over the year or more that I've been involved, communication has been good. If there are extensions of time, which they seem to frequently seek, we get notified. In this particular motion cycle that occurred, we had a deadline of October 27th. It was supposed to be October 24th, actually, and co-counsel actually said in court, why don't you make it the 27th? We'll give you the weekend. That was the nice, generous, olive branch to do that. And on October 24th at 5 p.m., there was a motion filed seeking an extension. Clearly, given the timing of that filing, it doesn't put us in any position to respond and oppose it. We didn't, never complained. We knew it was going to be granted. Court, or the former court anyway, gave them until November 17th to finish their filings. That was yesterday. That came and went. There was no filing. There's still, to this date, literally on November 18th after 6 o'clock, has been no filing. More interesting is there's been no communication, which is not normal in the course of the relationship of this case. As I said, it's been anything but collegial, appropriate, professional. And, Linda will obviously know this, having been in high level practice for all these years. What real lawyers always do is talk to lawyers, even on contentious cases. And if they need more time, they would tell you, even if they don't have a good excuse. I'm just letting you know. And the reality is, we've heard nothing, not a peep. And that's troubling for a number of reasons. One, it calls into question the professionalism, frankly, about it. But also, we want to appear on December 5th and argue and have this case dismissed. And the longer this fiasco drags on and we're not presented with their reply, that harms our ability, my ability personally, to prepare to do what I have to do. I have other cases to work on. I have other things to do, and set aside time to work on certain things like any professional attorney. And, we've now lost 2 days of real time that frankly I had put aside to look at this right away and outline some thoughts about what to say in court, or even consider the possibility of seeking leave of court to file a reply brief, to get that in front of the judge. And so we are losing time. We are not being provided any notice. And this just appears to be the latest thing that happens in this county, where nothing is normal, nothing is done in the way it should be. But in this particular case, to have no communication from the prosecutor is alarming. That's unique so far.
Don't you find it interesting? And maybe me, as I'm not a conspiracy theorist, but you have a new judge that was appointed. I don't know whether you had noticed that that new judge was coming, and all of a sudden you don't hear from the prosecution. Have you thought of whether there is a connection between the two, especially since Cosgrove did have to leave one of the cases because of a conflict of interest?
So I guess in the first instance, we had no idea what was going on, behind the kimono, if you will, in terms of the judicial assignments. We did not ask for it. The prosecution did not ask for it. We were unaware it was happening. We just got emailed an order late last week, I think Friday, saying this happened. And it's interesting. And I can think of some reasons why perhaps that might have happened, but I'll keep that to myself. I don't want to speculate too much about that. In terms of why would it happen? How does it relate to what's happening now with the prosecution? I don't think so. I think it is to our advantage, frankly, to have one judge familiarized, in this case himself, with all the evidence, because I think it strongly favors us. We had no say in it. We just, as I like to say, we go where they send us. They tell us when to show up, what's on tap that day, and we'll do it, whether we agree with it or not. So, I don't know why this happened. We're fine with it. We're not concerned that the judge is from Canton, which is true, apparently. I can't look and see goblins in every window and just assume that has anything to do with it. I mean, look, I think the facts and law are on our side. I think this case is destined to circle the drain. It's just a matter of when. The frustrating part is that we've had December 5th circled for a long time, and we bust our hump to meet deadlines. We work hard all the time. We have 27 different matters going on at the same time, but we do whatever we need to do to get all the information in front of the court to keep the schedule, which we want. And that schedule is now being jeopardized by a complete lack of communication at all on what they're doing. And frankly, it's insane to me.
Yeah. This new judge, it seems to me, we're surprised when something that makes sense happens. And it does make sense that they bring a judge in to consolidate these matters. Makes perfect sense. But it's Massachusetts, so we're like, oh, what the hell's going on? Something's wrong here.